All right, let's dive deep into jurisprudence. Today, we're not just talking about laws, but like the whole foundation of law.
Yeah, it's about going deeper than memorizing rules. It's more about the philosophy, history, even cultural things that shape how laws are made.
Like the why behind the what, right. And you know what's really cool? You gave us a bunch of texts a lot about Indian jurisprudence, which is fascinating. There's this jurisprudence.pdf. That seems like the main one. But then these other documents that, I don't know, they seem like they might have different opinions. Should be interesting.
Yeah, it'll be cool to see how it all fits together.
So first things first. What exactly is jurisprudence? Like, what are we even talking about here?
Jurisprudence is, well, it's kind of like the DNA of law. It's the study of the nature of law, the principles behind it, and how it works in society. So it's not just the what of the law, but the why, which is, super important for anyone who deals with the legal system, whether professionally or even just as a citizen.
Yeah, like if you think of the legal system as like a car, jurisprudence is like looking under the hood and seeing how all the parts work.
Exactly.
And from what I see in jurisprudence.pdf, there are a few different definitions of jurisprudence. It seems like people can't even agree on what it is exactly.
Yeah, it's true. It can be a bit slippery to define. Like legal theory is usually considered part of jurisprudence, but it's more specifically focused on analyzing legal concepts and principles.
Okay, so jurisprudence is like the big picture, and legal theory is like a specific tool within that.
Precisely.
Got it. So one of the things that comes up a lot in jurisprudence.pdf is how to categorize laws, like trying to organize them into different buckets, right? It talks about public versus private, criminal versus civil, substantive versus procedural.
Oh, yeah. There's a lot there.
I'm guessing you don't need me to give you a lecture on the difference between public and private law, though.
Probably not. But as a quick refresher, public law governs the relationship between individuals and the state, while private law focuses on relationships between individuals and private entities.
Okay, so public law is like constitutional law, criminal law. And private law is more about contracts, property rights, that kind of thing.
Exactly.
Makes sense. And then there's the difference between criminal law, which is about offenses against the state, like theft or assault,
right,
and civil law, which is about harms done to individuals like breach of contract, negligence.
No.
Okay, so that leads us to another important distinction. Substantive law versus procedural law.
Right. Substantive law is like the substance of the law. It defines our rights and duties, what we can and can't do. And then procedural law is like how we enforce those rights, the process.
So substantive law tells us what we can and can't do. And procedural law is like the rule book for how a legal case works its way through court, right?
Perfect analogy.
I'm getting it. And it seems like understanding these categories is important, not just for lawyers, but for anyone who wants to like navigate the legal system.
Absolutely.
So beyond just classifying laws, jurisprudence.pdf also talks about the purpose of law. And this is where things start to get kind of philosophical.
Yeah, it's interesting.
Like it talks about how law is not just about punishment. It's also about, upholding rights, making sure society is orderly, and ensuring justice. It even mentions protecting the nation from outside threats.
Right. It talks about having a politically organized society.
And how the government uses force to uphold rights and enforce the law, which I don't know about you, but makes me think a little bit.
It's a powerful concept. The use of force in upholding justice is, it's complex.
Definitely complex.
Yeah.
Makes you wonder about the balance between power and what we consider just...
Absolutely. And that balance is always shifting, especially in a place like India with, so much diversity and constant change.
Speaking of India, the text also highlights how law has been used for social change in India, which is really cool.
It is. It's a great example of how legal principles translate into real-world change.
Yeah, there's this whole section listing examples. The right to education, PILs, the Right to Information Act, marriage laws, prisoner rights, and a bunch more. It's pretty impressive how the Indian legal system has tackled these issues.
It is.
Let's dig into a couple of those examples a bit more just to get a feel for the impact. PILs, public interest litigations. Those seem pretty unique to India. What's the big deal about them?
PILs have been huge. Imagine a community is facing, say, environmental damage from a factory, but they don't have the means to fight a legal battle.
Right.
PILs allow anyone, a citizen, a group, to go to court on behalf of people who can't access justice themselves.
So it's like giving a voice to those who wouldn't otherwise have one.
Exactly. PILs have been used for things like environmental protection, fighting for the rights of marginalized groups, even challenging government policies that violate fundamental rights.
It's almost like leveling the playing field, making sure everyone has access to justice no matter who they are.
Yeah, it's a powerful tool.
Okay, what about the Right to Information Act? That one sounds interesting, too.
So the Right to Information Act, or RTI, lets citizens get information that's held by public authorities.
So, like, I could ask for information about government spending, or, like, how they make certain decisions.
Exactly. The whole point of the RTI is transparency and holding people accountable. It lets citizens see what's going on with the government, and it can help expose corruption, you know?
Yeah, that makes sense.
When people have information, they can make sure that the government's working in their best interest.
Powerful stuff. So we've seen how law can be used for social change, but it's not always that straightforward, is it? Because there are all these different schools of thought within jurisprudence, like different ways of looking at what law is and how it should work. Jurisprudence.pdf touches on this a bit, and then we have these other sources that seem to go deeper into specific schools.
You're right. It's a field with lots of debate.
So we already talked about how laws are classified, but now it's like we're zooming out even more and asking, like, what is law even? And it seems like different schools of thought have different answers. Like, you have the historical school, which says that law comes from a society's customs and traditions.
Yeah, they see it as an organic thing, rooted in the spirit of the people.
So instead of like some abstract rules that are imposed from above, it's more like law grows from the bottom up.
Exactly. To understand a legal system, you need to understand its history and culture.
Okay, that makes sense. But then how do you even define the spirit of a people? And how do you know when a law actually reflects those values?
Those are great questions. And especially in a country like India with so many different cultures, it gets even more complex.
For sure. Okay, so that's the historical school. What other schools of thought should we be thinking about?
Well, how about the realist school? It popped up in the U.S. in the early 1900s.
Mm-hmm.
Legal realists were really focused on how law actually works in the real world, not just in theory.
So they were less interested in abstract ideas of justice and more interested in what was actually happening in courtrooms and people's lives.
Exactly. They weren't so into those grand legal theories. They were more interested in what judges actually do, because they argued that judges are influenced by more than just legal precedent, you know?
Right, so things like their personal beliefs, social context, even political pressures could play a role.
Exactly. Legal realists wanted to study how judges behave, how social and economic factors affect their decisions, and like the difference between what the law says and how it's actually used.
So they were acknowledging that law is a human thing, not just this set of rules floating in the air somewhere.
Right, it's made and enforced by people.
Right, which makes it messy and unpredictable.
Absolutely.
This is already blowing my mind. We've gone from classifying laws to like the purpose of law, from the spirit of society to like what judges are thinking, and it feels like we've just scratched the surface.
Oh yeah, we've just started.
Bring it on. But before we get too carried away, there's one name that keeps popping up in jurisprudence.pdf, and it seems like we can't talk about jurisprudence without talking about him. John Austin and his command theory of law.
Ah, yes. Austin.
So what's the deal with this command theory? Like, what's he saying?
So Austin is a big name in legal positivism, which is the idea that law is basically a set of rules created and enforced by a sovereign authority. And his command theory says that law is just a command given by a sovereign, and if you don't obey, there's a punishment.
So it's like the sovereign is saying, do this or else.
Basically, yeah. For Austin, a law has to have three things: a command, a sovereign, and a sanction.
Okay, let's break that down. Command seems pretty straightforward. It's the rule itself, what the sovereign wants people to do or not do.
Right.
And sovereign is like the ultimate authority, right? The one who makes the rules and has the power to enforce them.
Exactly.
So in a monarchy, that would be the king or queen. But in a democracy, it gets a bit more complicated, doesn't it?
It does. Figuring out who the sovereign is in a modern democracy with, checks and balances and all that is tricky for Austin's theory.
Right.
But let's keep it simple for now. The third part is the sanction, which is just the punishment for breaking the rule.
So if you break the law, you face the consequences.
Right.
Whether it's a fine, jail time, or whatever. And for Austin, that's what gives law its teeth. Without the threat of punishment, it's just words on paper.
That's the idea.
Okay, I get it. But I have to admit, this theory already feels a bit too, simplistic. Like, it doesn't quite capture how complex law really is.
You're right to be skeptical.
And even jurisprudence.pdf brings up some criticisms of Austin's theory.
Yeah, it does.
Like, it has trouble explaining laws that give people rights or benefits, like the right to education or health care.
Right. Those aren't really commands in the traditional sense.
More like entitlements, guarantees.
Exactly. And Austin's theory also has a hard time explaining customary law, which develops over time through practice, not from someone issuing a command.
Right. Like, customary law is about tradition and what people do, not some top-down decree. And especially in India, with so many different customary practices, that distinction seems important.
Very important. It shows why we need theories of law that can handle all these different kinds of legal experiences.
So Austin's theory might be a good starting point, but it's clearly not the whole picture. We need more nuanced ideas to really understand how law works.
You're absolutely right. Jurisprudence is about exploring different views, questioning things, and getting a better understanding of the legal world.
This is so interesting. We've talked about classifying laws, then their purpose, then the spirit of society, and now even what judges are thinking. It's like we're peeling back layers of an onion, and it just keeps getting more interesting.
And there's still more layers to go.
I can't wait. But I think we should pause here and pick up our deep dive in part 2. All right, we're back for more jurisprudence. Last time we covered a lot of ground, like how laws are categorized in some of those big schools of thought, the historical and realist schools. Now I'm kind of ready to get into the really deep stuff.
Okay, let's get philosophical then.
Yeah, let's talk about, like, justice and morality,
Yeah.
the big questions about what law really is.
Sounds good. Our sources get into some really interesting concepts. One that jumped out at me was distributive justice. It's about, like, how resources and burdens should be shared fairly in a society.
Distributive justice. So basically figuring out how to slice the pie so everyone gets a fair share, which, is easier said than done.
Oh, absolutely. Especially in a diverse society, there are tons of different ideas about what's fair.
Right. And the sources actually talk about how Western views on distributive justice are sometimes different from what you find in Indian jurisprudence.
Yeah, they mentioned John Rawls, who was he was an American philosopher. He came up with this thought experiment called the original position.
The original position. Okay, I'm intrigued. Lay it on me.
So Rawls asks us to imagine we're creating a just society from scratch. But there's a catch. We don't know what our place in that society will be.
Okay.
Like, we don't know if we'll be rich or poor, healthy or sick, talented or not. We don't even know our social status.
So it's like we're designing the society, but we're totally blind to where we'll end up.
Exactly. It's like being behind a veil of ignorance. And Rawls argues that if we were in this original position, we naturally choose principles that guarantee fairness for everyone, even the people who are worst off.
Yeah, that makes sense. If you don't know what hand you'll be dealt, you want to make sure the game is fair for everyone.
Right. It's a pretty strong argument for things like social safety nets, universal health care, making sure everyone has access to education.
It really makes you think, like, would I have the same ideas about fairness if I didn't know where I'd end up in society?
That's a good question to ask yourself.
It is. So distributive justice is about making sure everyone has a fair shot, right? But what about when things go wrong? Like when someone is actually harmed?
Right. That brings us to another concept the sources talk about. Compensatory jurisprudence.
Compensatory jurisprudence, another new term for me. What's that one all about?
It focuses on making things right after someone's been wronged, usually through compensation. Like, think about lawsuits where someone is seeking damages for, say, an injury caused by negligence.
It's about restoring balance, like trying to make up for the harm that's been done.
Yeah, that's the idea. But then it raises some tricky questions about, like, how do we actually measure harm? How do you put a price on pain and suffering?
Yeah, that's going to be tough. And I wonder how this idea of compensatory jurisprudence works in a place like India, where, cultural values and social norms might affect how people view harm.
That's a great point. The sources actually get into how law intersects with cultural traditions and social norms, even touching on things like moral policing in India.
Moral policing, that sounds like a loaded term.
It is a tricky area. It's about, like, when people try to control others' behavior based on their own moral values. Often it's not even the government doing it, but like social groups or individuals.
Right.
The sources present a pretty balanced view, though. They talk about the concerns with moral policing, but they also acknowledge that societies do need to uphold certain values.
Yeah, it's that age-old tension between individual freedom and the needs of society.
Exactly.
Where do you draw the line? What role should the law play in telling people how to behave, especially in a country as diverse as India?
It's an ongoing debate, for sure. And the sources use the example of obscenity laws, which I thought was interesting.
Oh, yeah, because what's considered obscene to one person might be totally fine to someone else.
Exactly. And then how do you define obscenity in a way that respects everyone's cultural values? It's a tough one.
Definitely. This whole conversation about moral policing and individual freedom makes me think back to something we touched on earlier, mens rea, the guilty mind. We talked about it in the context of statutory offenses, but it feels like there's more to it.
Oh, there's definitely more to it. It's a core idea in criminal law, but it can get pretty complicated. The sources talk about how mens rea gets tricky when you're dealing with, offenses against property.
So it's not just about intending to do something wrong, but also about, how aware you were of the consequences of your actions.
Exactly. They give some interesting examples, like, what if someone accidentally damages someone else's property? Are they still criminally liable?
Well, I mean, accidents happen, right? But I guess the law has to distinguish between different types of situations.
It does. A lot of times, the law differentiates between harm that's done intentionally versus harm that's done negligently.
So, in the case of accidental damage, it would depend on whether the person was being reckless or careless.
Yeah, that's one way to look at it. But then it gets even more nuanced. The sources talk about this principle called doli incapax, which basically means incapable of wrong.
Doli incapax sounds like something out of Harry Potter.
Kind of. But it's actually a really important legal concept. It recognizes that kids under a certain age, their brains aren't fully developed, so they might not understand that what they're doing is wrong.
So even if they do something that would be a crime for an adult, they might not be held responsible because they lack the mental capacity to understand the consequences.
Exactly. It shows that mens rea isn't a simple yes or no question. It takes into account things like age, mental ability, even cultural background.
Wow, this is getting deep. I'm really starting to see how much jurisprudence is about the human side of law. It's not just these abstract principles. It's about real people making choices and dealing with the consequences.
I think that's a great way to put it. Jurisprudence is about connecting legal theory to how people actually behave in the real world.
Okay, so we've talked about distributive justice, compensatory jurisprudence, mens rea, and we even touched on the whole issue of law and cultural traditions. Where do we go from here? What other adventures await us in the land of jurisprudence?
Well, there's still a whole universe of legal thought out there.
Yeah.
The sources point us towards some really influential schools of thought that have shaped how we think about law. Want to explore those a bit.
Lead the way. I'm ready for more.
Okay, let's start with a school of thought that has deep roots in both Western and Indian philosophy. The natural law school.
Natural law school. Does that mean they believe laws are found in nature, like the laws of physics?
Not quite. Natural law theorists say that there are these universal moral principles that are built into human nature, and our laws should be based on those principles.
So it's like there's a higher law, a moral code that's above the laws made by governments.
Exactly. And they argue that if a human-made law goes against natural law, it's unjust, and maybe we shouldn't even obey it.
Whoa, that's pretty radical. But then who gets to decide what these universal moral principles are? Seems like there could be a lot of disagreement about that.
You're right. That's one of the big debates within natural law theory. Some say these principles are self-evident, that we can figure them out through reason. Others say they come from divine revelation or religious teachings.
Yeah, I can see how that could get messy, especially in a world with so many different religions and beliefs.
For sure. And the sources actually bring this up by looking at how the idea of dharma in Hindu jurisprudence kind of lines up with natural law theory.
Dharma, that's the concept of duty and righteousness, right? The one we talked about earlier.
Yeah, that's the one. And with its focus on aligning yourself with a higher moral order, dharma could be seen as a kind of natural law in the Indian context. It says that there's this moral code that's bigger than any human-made laws, and we have a duty to follow it.
It's fascinating how different cultures have tried to figure out this relationship between law, morality, and human nature.
It is. And it shows that jurisprudence isn't just about studying different legal systems, but also about understanding their history, philosophy, and culture.
Okay, so that's natural law. What other big schools of thought should we be aware of?
Let's hop back across the pond to the U.S. and check out legal realism, which we touched on earlier.
Legal realism. So did they think all the other schools of thought were being unrealistic?
Not necessarily.
Mm-hmm.
But they were definitely reacting against what they saw as flaws in those more formalistic legal theories, like the stuff that John Austin and other positivists were talking about.
Right.
They thought those theories focused too much on abstract rules and didn't pay enough attention to how law actually works in the real world.
So instead of just reading about law in books, they wanted to see it in action, like what was happening in courts and in people's lives.
Exactly. They said law isn't just a bunch of rules, but a dynamic system that's always changing, shaped by social, economic, and political stuff. And they were super interested in how judges make decisions.
Because judges are human, right? They're not just robots following the law blindly.
Right. And legal realists believed that to understand law, you got to understand the people who create it and enforce it.
So their biases, their backgrounds, their views on the world, all that stuff matters.
Absolutely. Legal realists wanted to study how judges behave, what influences their decisions, and the difference between what the law says and what actually happens.
So they were bringing a more, grounded approach to legal theory.
Yeah, they were more pragmatic, more focused on the real world, and their ideas have had a big impact on legal scholarship, even in fields like law and economics, critical legal studies, and feminist legal theory.
Wow, this is incredible. We've gone from natural law to legal realism, from ancient Indian ideas to modern American theories. It's like a whirlwind tour of legal thought.
And we've just scratched the surface. But I think we've laid some good groundwork for understanding the many different ways of thinking about law.
For sure. And it shows that jurisprudence is not about finding one right answer, but about exploring all these different perspectives.
Exactly. And as we wrap up this deep dive, I'm reminded of a really interesting question from the source material: the relationship between law and liberty.
Law and liberty, those two ideas seem kind of at odds with each other, don't they?
They can be, but the sources point out that law can actually be both a protector of liberty and a potential threat to it.
So, on one hand, law can protect our freedoms by creating a fair and orderly society,
Right.
protecting us from harm, making sure our rights are respected. But on the other hand, it can also be used to silence people, control their behavior, and reinforce existing power structures.
Exactly. It all comes down to how law is created, interpreted, and used.
It's like walking a tightrope, trying to find that balance where law protects our freedoms without taking them away.
That's a great analogy.
Yeah.
And it's a balance that takes constant work, critical thinking, and a willingness to have open and honest conversations about the role of law in our lives.
Well said. This has been an amazing journey. I feel like I've gained a whole new understanding of what jurisprudence is all about. It's not just rules and regulations, it's about wrestling with these huge questions about justice, fairness, and how law shapes our lives.
It's been great exploring these ideas with you. And remember, the journey of understanding law and justice never really ends. So keep asking questions, keep exploring, and keep digging deeper into the world of jurisprudence.
Wow, we're already on the last part of our jurisprudence deep dive. It's amazing how much we've covered, from basic legal categories to those really philosophical ideas about dharma and natural law. I feel like I'm starting to get it, Jurisprudence isn't just about knowing the rules, it's about understanding what law really is and how it affects society.
It's been quite a journey through all these different legal ideas. We've seen how law is shaped by so many things like history, culture, even individual perspectives.
Yeah, and speaking of history, our source material actually takes us through a historical tour of legal thought. It's kind of cool to see how these ideas have evolved over time.
It's like tracing the family tree of legal concepts.
Right, like how have historical events and changing values influenced the way we think about law?
Exactly. It shows that jurisprudence isn't just about studying the law as it is now, but also understanding where it came from. The sources even talk about the impact of ancient Roman legal thought on modern jurisprudence.
Oh, yeah, the Romans. Their legal system was pretty advanced for its time, right? I vaguely remember learning about the 12 tables of Roman law back in school.
Yeah, the Romans were ahead of their time in a lot of ways. They developed a very sophisticated legal system, and a lot of their concepts, like the distinction between public and private law, are still around today.
It's crazy how ideas can travel across time and space like that, shaping the way we think about law and justice.
It really is. It shows how jurisprudence is a global conversation. Yeah. Something that connects people across different countries and time periods.
So we've talked about natural law, legal realism, even ancient Rome. As we wrap up, what other big schools of thought should we have on our radar?
Let's touch on one more that's been super influential. Utilitarianism.
Utilitarianism. I've heard the term, but I'm not sure what it means in terms of law.
Well, basically, utilitarianism is about trying to create the most happiness and well-being for the most people while also minimizing suffering. It's all about the consequences of actions.
So a utilitarian would say that a good law is one that benefits the majority, even if it means some people might lose out.
Exactly. Utilitarianism has been a big influence on things like healthcare reform and environmental protection laws. The idea is that these laws might limit individual freedoms in some ways, but in the end, they create more happiness and well-being for society as a whole.
It's like finding that balance between what's good for individuals and what's good for everyone.
Yeah, that's the key. But utilitarianism can be controversial,
Wow.
Like, who decides what the greatest good is? And what about the people who end up worse off because of a law, even if it benefits most people?
Right. That's a good point. It seems like every school of thought we've talked about has its own set of pros and cons. There's no easy answer when it comes to law and justice.
That's what makes jurisprudence so interesting. It's an ongoing conversation, a process of questioning and trying to understand the legal world from different angles.
Totally. And I have to say, this deep dive has really opened my eyes to how complex and nuanced law is. It's not just about rules and punishments. It's about these big questions of justice, fairness, and how law affects our lives in so many ways.
I'm glad you found it insightful. And remember, this is just the beginning of the journey. There's always more to learn and explore in the world of jurisprudence. So keep asking questions, keep challenging your assumptions, and keep digging deeper into the fascinating world of law and justice.
I definitely will. Thanks for taking me on this deep dive. It's been a real eye-opener.